radio
morning,
content.
Joe Brusic.
Good morning, gentlemen.
Yeah.
Thank you very much. It's always an honor and privilege to be on your show.
Well, I wouldn't go that far, Joe, but it's good
And
to have you.
It is.
It's always an honor to have you here too, Joe.
Thank you.
Still trying to figure out. I say that in the story, County Prosecutor Joe Brusic says you and prosecutors around the state are still trying to figure out the full impact of the state Supreme Court ruling. And some action yesterday by the House. So I guess first of all, where are we at this point? Have you figured it out?
This decision by 5 of the 9 Supreme Court justices came down, as you indicate, on February 25th, and it was in the justice realm of what we do on a daily basis. This was monumental. Some of us, as prosecutors, have said that it's probably one of the biggest decisions that we'll ever have to deal with.
Yeah.
And it's really earth-shattering because the statute that actually criminalized the types of possession that we're dealing with was created initially in 1971. So literally, because this particular statute dealing with possession of controlled substances was declared unconstitutional, it's retroactive. So we've got to deal with issues going all the way back to 1971 to the present day and then moving forward prospectively. So it's huge. And
have you done any of that yet? I mean, has anyone in Yakima been, I guess, they had their records scrubbed or been released from jail or anything like that?
Well, I can tell you unequivocally, so far we are getting close to 300 felony cases that we've had to dismiss because of the ruling. That's felony drug possession cases that have been dismissed, some of which are with prejudice versus without. But there's no question this is monumental. I mean, this is affecting everything in our system.
Give us an example of one of those cases. I mean, is it because we're talking about simple possession, but felony possession?
Yeah.
How does it? Give us an example of one of those cases.
Well, essentially, the decision by the Supreme Court basically legalized the possession of drugs that we cannot prove they were possessing to distribute or to sell, right? Possession with intent to distribute or sell is a whole different situation. We can still prosecute those. These are simple possessions. So if you possess meth, coke, mushrooms, felony amounts of marijuana, your cocaine, those have been decriminalized.
But there's no felony amount of cocaine, right?
No.
So if you had cocaine, then it was...
Yeah, but if you had a kilo in the trunk, that's not personal use, right? So that's that intent to distribute thing?
Well, that's what we would say. Possession with intent is different. But we need indicia under the law to be able to show that it's not for personal use. So, if you have 15 fentanyl pills, is that enough to show possession with intent to deliver? Arguably not. And the 15 fentanyl pills, those run from anywhere from $20 to $30 a pop. That's a lot of money out on the street market, right? So if you have 15 fentanyl pills, we can't prosecute you for that.
Well,
and you can't be arrested for it.
Well, let's say there were 15. Isn't that up to the jury ultimately to decide if that was enough to indicate intent to sell? Or does it say on the statute, clearly 15 or less? I mean, if it doesn't, then are we just taking a chance at what a judge or a jury will say? Is that what it
Well, the statute is the only drug that is dealt with in terms of quantity is marijuana. And we know that was decriminalized about 10 years ago in terms of anything over a certain amount. Less than that amount, it is not criminal to possess marijuana, obviously. But with these other drugs, it's not clear. The statute is not clear on that. And so the first thing that is looked at is a police officer that does the investigation. They send the case up as a referred allegation. And we make the final charging decisions as prosecutors, and we evaluate the totality of the evidence, and we determine that whether they should be charged with possession with intent or simply possession. Well, now there's no possession. So if we don't have possession with intent, and an example would be if they had, say 30 pills, but they also had packaging, they had scales, if it's like a powdery substance. There's certain things that we look at to be able to say, okay, this is clearly done for the purposes of delivery. Then it's a different ballgame. But the first thing before it would ever get to a jury is obviously go through pretrial motions the defense counsel would bring, indicating that we can't prove that particular charge.
Yeah, so, I mean, you get caught with a half pound of cocaine, and your attorney's just basically saying, tell them it's for personal use.
Yeah. Yes, sir. That's it.
And as long as you weren't caught with the bags and the scales and all the other stuff next to it, but even then.
Well, I mean, once again, it's
Even
all
then it's
discretionary. We
yeah.
charge that out. The judge
Yeah.
potentially allows it to go to a trial. And then
Yeah.
ultimately, if we get it to the jury considers the evidence, follows the law give it to it by the judge, and then makes a decision as to whether it was possessed with intent to deliver.
Okay.
But it's the ruling on February 25th is much greater than that, because it deals with not just that in terms of our ability to charge currently those cases, but it deals with people that have been convicted of those cases. When it says that it's unconstitutional, it means those convictions go away. And so that's what we're struggling with now. We're struggling with vacating, entering into vacating orders that indicate that those convictions no longer exist for those individuals. Well, for some of these people that are in prison, they're in prison with a certain standard range under the SRA. And those, if you take those possession of controlled substance convictions away, it changes their standard range sentencing. And for some of those individuals, they will be getting out of prison early because of it.
Yeah. All right, KIT News Time, 7:54. We are talking with Yakima County Prosecutor Joe Brusic about a ruling in the state Supreme Court that, said the state's simple possession drug law was unconstitutional. House yesterday out with a package of bills, or actually, I think it was Monday.
Were you consulted or asked to consult
Yeah.
in any of
Yeah.
those sorts of the structure of those bills?
Yes. Well, not personally. What we have been doing since February 25th is in fact, even as of yesterday, the civil prosecutors around the state met on a Zoom call. We, as elected prosecutors, have been meeting once or twice a week through Zoom to discuss all these issues. And the issues are just, they're exponentially growing, literally. And so we have an executive director, Russ Brown, who represents the 39 elected prosecutors. And we discuss these issues. And on these particular Zoom calls, we routinely have anywhere from 25 to 30 of the 39 prosecutors that are throughout to discuss these issues. And then he takes us back as our lobbyist representing the Washington Association of Prosecuting Attorneys. So we are consulted. We do give our opinions. I'm on the legislative committee for WAPA, and so we are involved in these decisions that we want those individuals, those legislators, to know about, and they know that this is a problem. What we have been told is that the legislators are not as concerned about what has happened in the past, which to us is a huge issue. It also is affected directly through legal financial obligations. One of the biggest things that's going to come about from this Supreme Court ruling is that we've got to, it's not just a matter of getting rid of the conviction. It's a matter of returning all the money. So if these individuals that were convicted of these particular crimes paid money, they get it back. Who's going to pay for that? Right now, they're saying
get it with interest.
No, they've determined that it won't be with interest. But right now, the legislature they're considering whether they need to put aside potentially, just for right now, $100 to $200 million. 50 years is a long time ago, right?
Yeah.
And for these individuals to have made payments on LFOs. Now, some of these individuals that were convicted of these crimes haven't paid anything. They don't get any money back, obviously.
Well, that tells me something right there. I mean, if they're thinking about putting money aside, they're not thinking about overturning this law. They're not.
Well, the one thing that the easiest fix for us as prosecutors, and they've made it clear they're not going to do this, is to add in a mens rea element of knowingly possess.
Isn't that what the House tried to do yesterday?
Yeah, but it's not yes, but it's most likely from everything that we've been told through WAPA is not going to work. One of the big side issues right now is whether counties and cities can actually create a misdemeanor to create a crime for possession of these drugs. It would only be a misdemeanor, would not be a felony, and we're looking into that as well, even as we speak. And last week met with our county commissioners to talk about that issue, and we'll be doing some more talking on that here in the next few days. But the reality is we're trying to figure out what to do with this now, and there's a lot of fixes that are trying to come about. But one fix that we're not very hopeful for is that they're going to just simply change the statute. And the reason is because, once again, the House and the Senate are both controlled by individuals that believe that a major part of this ruling was about the racial disproportionality, and that it affects those individuals more so than others. And because of that, they're not interested really in changing, because they see from their perspective, whether you agree or disagree, from their perspective, the merits of the change. And they were already looking into it legislatively to go down this road, very similar to what Oregon had done recently through their legislature.
So if I can take what you said and reshape it, the equity crowd is under the impression that more people were put away for possession than not, that minorities or people of color were, even if they did know, right? Because the assumption is within 50 years of cases, give me a number, 95% knew they had the drugs on them, 98% knew they had the drugs on them, 99%?
Well, we don't have a percentage, but I can tell you that the unwitting possession defense, affirmative defense, that a defendant, once the state, we have to prove a prima facie case to get it past what we routinely call a halftime motion to the judge for dismissal if we're in trial. If we get it past that point, then the defense makes a decision whether they present evidence or not. They are under no burden to do so. But if they choose to do that, they have an unwitting possession affirmative defense that they bring, and it was created in 1981. Most of these cases, we prove, and that's part of the problem, is that the legislature, and as it turns out, our Supreme Court determined that in this particular case from Spokane County, which created the law, Blake, a young lady that was found to have apparently put on jeans from somebody else that had a baggie of meth.
Happens to me all the time.
And so the reality is what we're dealing with is moving in a direction of saying that this is essentially strict liability, and it was unfair and unconstitutional on that ground. And the Supreme Court knew exactly what we were going to try to do after that decision, because in the same decision said, and as simply adding a knowingly mens rea, a mental element to the crime, is not going to work as a fix.
So the only fix is their prescription, which is to take it down to zero, start back 50 years or whatever, and start making the case when you pursue these cases. There's no.
Well, we're looking at what we can do as our options, but they're limited right now. And there's been this attack on drugs for a number of years now, both legislatively and through the court system. And once again, regardless of whether you agree or disagree, they were headed in this direction. The state of Washington was in general.